Ladies and gentlemen, welcome to the show today. An entertainment and media lawyer shaping how African creativity is protected, valued, and monetized. Please welcome to the show, Kofoworola Eze. I had to take my time on that pronunciation.
Lagos, this is your city, your sound.
Can you say that again?
Hey.
Okay.
Thank you for having me.
Thank you so much for coming.
Yeah.
Thank you so much for coming. It's been a pleasure tracking you down and finally meeting you in person. And like I said, you look different from social media. You actually look better.
Okay.
You want to ask if it's different? Different? It's very, very good different. Okay. It's very, very good different.
I can take that then.
Welcome to the show.
Yeah.
Okay, so let's start from the basics because a lot of people who are listening in may not know what exactly is intellectual property and what is copyright.
Okay, so copyright essentially just means the right that an artist or a creator owns for its original idea. Mm-hmm. So take it from an artist, an artist, a musician, an actor, mm-hmm. their original work that is being created in its tangible form, right? Mm-hmm. Yeah, that's just what copyright is. So it's the protection that is given to them by the law. And so, for you to have this right, it helps you to be able to claim ownership of this right. It helps you to also be able to make money from your work. That's why it's very important.
That's copyright.
Yeah.
And it's also related to intellectual property.
Okay, so copyright is a form of intellectual property. Yeah, so intellectual property is divided into different forms of right. So from copyright to trademarks, to trade secrets, to patents. Patents deals with the fabrics, people, the fashion guys, and all of that invention. Then trademark, your brand assets, CTFM's brand assets, the color, all of this. Yeah, they're covered under trademark. And copyright is the protection of an original idea, like the music, what we're doing here, podcast, and all of that. Yes.
Oh, okay. That's fantastic. So what are some common ways you've seen creatives' rights being infringed upon, whether in music, film, or media?
I mean, a lot of ways. From not crediting them properly to using their work without permission to even exploiting. There was a recent video I saw about a very popular gospel artist that came online and was talking about how gospel artists would do covers of songs, right? So all of these things are some form of infringement. If you don't get permission to be able to do that, and then you go ahead to put it on your Spotify or your Apple Music and all of that.
That's if you want to monetize it.
Yeah, monetize it.
But is there what is fair use in this sense? Because now that you mentioned gospel artists, I know that in the gospel circle, so if, let's say Dusin Oyekon releases a song, that Sunday they're singing it in church. Does that qualify as infringement? Okay,
so the use there is not being exploited or monetized.
Okay,
so that's one of the thin lines that you used to draw a margin between what is fair and what is not fair. For instance, you can use someone's work to teach. You can use it for personal use. You can use it for maybe education purposes. You can also use it in church, just like I said, for all those kind of things. And it's not being exploited. It's not like the church is going online now to upload it on Spotify or on Apple Music and then start to earn royalties from it. So those are the thin lines that draw.
So for artists, producers, filmmakers listening right now, what are the practical steps that they could take to protect their intellectual property?
Okay, the first thing is obviously, creation. That's the first part, because in the industry where I am, I hear a lot of people say things like, "Oh, I have an idea. How do I protect my idea?" So, the first thing to do is to put that idea into a form that can be protected. So it's either you're putting it in you're writing it down, you are putting it on your laptop, whatever it is, whether it's scripts, whatever. After that, I would always advise you to go ahead and register your idea. It gives an additional layer of protection. But that's not to say that your work is not copyrighted the moment you create it. Yes, the copyright is automatic as long as it's original and it's fixed in a form. But, the going ahead to register, it gives you like an additional layer, and then you can always say, okay, I have an evidence, this is my certificate of registration. It makes the work easier when there's an infringement. Then your contracts, very important. In the creative industry, it's very common that you see actors or artists, people in creative generally want to do gentleman agreements. Oh, he's my guy now. It's not Rex that I know. Let's just sign an agreement now, you know, and let's pay for it. But it's not usually like that. The problem comes when you start to earn from it. Now money they cause problem. Yes now. So by the time money starts to come in, then fight starts to come in. So it's very important that aside from protecting, you go every contract you go into or every relationship you go into, you register, you sign contracts for them. It's very important.
I like you mentioned the creation of the work. So there's a kind of tangible form that represents that intellectual property. Because if it's still just in an idea phase in your head, you can't really, you know, defend that because you've not created anything with it. So does that mean that if you haven't, maybe you've created it on paper, for example,
then it has been created?
I know.
Okay.
And you now go on, you didn't register it, right, with any trademark organization or copyright organization, for example. And you go on to produce something with it. And what you've produced, maybe you didn't upload it online. You have it in a video format, for example, maybe an MP3, MP4 format, and it's on your phone. Somebody watches it and replicates it or even steals it from your phone. Now, because you've not published it to the world to see, someone does that ahead of you. How, in this case now, how can you prove that you did it first?
Okay, so what you need to first understand is that so there's copyright and there's derivation of copyright. So the mere fact that I probably wrote a script, that alone is a copyright work. If you go ahead and use that script to create a film, that's another copyright. The film itself, it's a work that is protected by copyright. Now, the mere fact that maybe I used a dubious way to get the script to create a film doesn't make the film invalid. Okay. Right? It doesn't make the film invalid. However, it now depends now on what you're able to show. So did you timestamp it? Did you probably email it to someone? Who did you show? You know, all of these things are actually stressful to prove. And the court of law would deal with facts, right? So if one person is able to come and say things like, okay, I registered, just like I previously said, it makes it easier for one to, judge based on facts. But there are other ways. I mean, like I said, did you email it to somebody? Is there a stamp on it? Did you use one of all these digital technologies that are being used now to protect your work? You know, all of these things to come to play when you're trying to prove your
because
rights.
I'm really asking this question for people who right now listening to us are not being very careful on how they are protecting their intellectual property, and it's a maybe my guy thing. Send me a beat, right? And it sends you the beat. So if you don't have an agreement with them, they go ahead to use it and try to say no, it's their own intellectual property. That WhatsApp message that is dated and stamped can also be used to substantiate your claim.
Should be able, yes. I mean, it's not a written agreement, but it could go
to say, I sent this
to you at this time. Yes.
And this was way before you released this work. So
yes, exactly.
That kind of stuff. Well, that's cool. There was also a case on I think a movie, and there were a lot of back and forth with who owned the intellectual property. It was Shantytown. Yes, there was it was like a high profile dispute, if you would say. And what lessons can people take away from cases like that about ownership and legal protection?
Well, for Shantytown, I think one lesson that one can take away, just like I've previously advised, is registration. I can't remember the writer's name. I think her name is Chine. Mora. Yes, exactly. So I remember. So I know that what made her win that case at the time was because she showed evidence of registration. So she had protected the work, and she had gone ahead to register and copyright the work at the registry. So I mean, the judge would only judge based on facts, right? So which was part of what she was able to. So before she even gave it to, I think, the producers of Shantytown, she had gone to to protect our work.
Yeah.
Which is very important, which is what I said. Because
which is a step a lot of people don't take. Because sometimes they think it's really expensive, but it's relatively affordable, right?
Yeah, it's not
to protect your work.
Yeah, you know.
So where can you protect your work? Say you're a script writer and you have a script, or you a songwriter. Copyright commission. Yeah. So you just need to pay some money and they give you a stamp or a certificate that you brought this so date. So it's like time stamping, but now with the government.
Yeah.
So it's a government record. Oh, that's fantastic. Yeah. Okay, that's interesting. So, supposing somebody infringes on your rights, what steps should you take? Should you call them out on Twitter, go on Instagram, drag their life, or what are your options available to a creative?
So I think the first thing a creative should always know first is that our industry is very relationship focused. So you don't want to be burning bridges too often, because then you I mean, everybody has one thing or the other to say about you and nobody really wants to work with you anymore. But I always advise people, when you know, become aware that somebody is infringing on your right, the first thing you should do is to notify them. So send them a cease and desist letter, send them a cease and desist notice, notify them of their infringements, and tell them that if they do not desist from doing this within a certain frame or immediately, right, you're going to seek redress in court. I mean, that's usually like the first step that, you know, we always advise creatives to take. And if after the period has elapsed and, you know, they're still not doing anything about it, take them to court properly and let the court of law do its thing. But aside from that, for music and even film, there are technological steps that can be taken down. For instance, you can take down songs, you can issue a takedown notice. Yeah. And those things are really fast, right? So once you notify these distribution platforms and let them know that, see, this person is using my work but without payment and all of that, and you're able to provide evidence that this is your work, they will take down the song before they even try to settle. They put a pause on it first before they even bring both parties together to say, okay, what's going on, resolve it. And once the moment you resolve and then you go back to them and tell them, oh, we've resolved, blah blah blah, they allow you to go back and upload your work. So that's another. I mean, that one is very rampant these days. A lot of artists, a lot of musicians, actors, they do it.
What you just need to do is report to maybe the distribution platform.
The platform, and then they just take down the song pending when you're able to resolve your issue. Okay.
One thing we've noticed is that a lot of artists, musicians, they jump into contracts, they sign away contracts, and when they know better or when money starts coming in, everyone now becomes a legal expert and like, you know what, I'm being ripped off. So how or what should creatives look out for in contracts that will help them avoid unknowingly signing away their intellectual property? Because there are certain clauses in that contract that once you sign it, just know that you're not really the full owner of this work.
Okay, so the first thing is to get the lawyer. I always say that. Make sure that when you're trying to build your team as a creative, you have a lawyer, and not just any lawyer, an entertainment lawyer or a lawyer in the field in entertainment that you are working in. So a music lawyer, a film lawyer.
They're very hard to come by these days.
But they are. I mean, if quick search on Google or Instagram, you'll get 1 or 2 or 3 or 4 or 5.
Okay. You get the popular guys and the expensive guys.
Why do people always think that way? See, the truth is that even the lawyers are in this industry. It's not like we don't know what's going on in the industry.
Okay.
I mean, but then again, there's something else. Every year we have, over 5,000 lawyers are being called to bar.
Yes. More of them should go into entertainment law, really.
I'm sure a lot of them are going into it. It's almost every time I have to speak with one school union or one. So the interest is actually already kicking up compared to when I started. But that should be the first thing. Try to get an entertainment lawyer to help you. Now, if I'm to talk about clauses, I might not go deep into clauses, but I might just give like an overview. So you want to be sure of things like ownership, like rights, who owns what, how long is this thing being owned by me? Okay, so take for instance, you're getting into a record label deal. You want to know as an artist, what exactly does the record label own? So does the record label own my songs before I got into the label? by virtue of this deal, or is it just the songs that I create during the term? You also want to know, am my songs or the rights in my songs going to revert? You want to be sure. Is the rights in my songs going to revert back? You want to be sure of that. You also want to know things like royalties. What am I getting from this? Okay, if the record label even owns a copyright in my work, what percentage am I earning?
Yeah.
Is the record label giving me some sort of money to maybe like some sort of advance? I don't really like to talk about advances a lot. So if you notice, I was trying to avoid it.
There's a sister word that comes with advance that most artists don't know, they won't like it. It's called recoupable.
Yes. So you want to be sure of terms and deals like that. You also want to know how long. So how long am I doing this for?
Yeah.
When is this label? So I'm using record label just for easy access because there are different contracts in entertainment. But more like, when is this label supposed to release my song? Is that when my term starts? These are things that you need to know. Do I even have the right to audit the account? Yeah, I want to know, can I audit the account of the income and revenues that come in? So these are things you need to know. Can I go out if there's an issue? If there's a breach, if the record label stops doing what they said they're going to do, what are my options? Can I go out? Can I leave the contract?
Will I have to forfeit my name and brand?
Who owns my name? Who owns my brand? Right. Even if we have issues, where do we go to resolve dispute resolutions?
Yeah.
These are the clauses that are very important.
Well, if that is doing your head somehow, just take our first advice, which is just get a lawyer.
Yes.
Okay, let's now talk about Sync.
Yeah.
That's something that you are into. So tell us about Sync Camp.
Okay, so Sync is one of the ways that artists earn from their songs. So think about the use of music in visual media, like TV, like films, like ads, like games. So the use of that music is what synchronization is. And synchronization royalties come from the composition side of music creation. So when I'm talking, I don't know how to leave the technicalities of it, but so from the lyrics to your melody, the income that your lyrics and your melody generates is part of what sync use is. It's usually called master and sync use, so depending on the use of music. And it's an avenue that is still growing in the industry, but we are trying to champion it. Afrobeat to the world, Nollywood to the world. So we're at the space where our music, our culture is being exported globally. So it's very important that as an artist, you try as much as possible to be open to earning from all of this. Opportunities. So that's it essentially. That's it.
So are you working with artists in terms of helping them understand?
So sometime in June, we had like a camp. We brought, it's a Sync camp. We're actually about to do another one pretty much, but we'll announce shortly. So it's a Sync camp that we brought together music creators to come together to create music. And aside from creating music, we also try to educate them on what it is. And because if you don't really understand what you're doing, what's the point of it? So we try to educate them, we try to make them see the opportunities in this industry, and we also allow them create music based on Sync. So having it in mind that this song might be used for a visual, for film, for visual media, for ads, depending on the opportunities that come. So there's this particular song. It's not a Nigerian song, but I think it's by do you watch Stranger Things?
Yes,
there's this Kate Bush song. I think it was released, I can't remember the name of the song, but it was released in 1985. And 40 years after, right, that song was topping charts globally. I'll remember the name and I'll let you know. So I'm just trying to let you understand the kind of opportunities that synchronizations can bring to music creators. So it's not everybody that will be in top 100.
Yes.
It's not everybody that will be in top 10. right? Some people can make music from film. Yeah, and we are all distributing and making the ecosystem stronger. Yeah.
Okay, and it's important for people who are making filmmakers to ensure that they clear these songs before syncing them. So how easy or difficult is it getting music cleared for sync?
It depends.
Or who is clearing it?
It also depends on the ownership. This is why it's first important as music creators to get their contracts right. So be clear on who owns what and to what extent, what percentage. If you are clear on this, it's easier for the Nollywood people, it's easier for the film producers, for the music supervisors to want to use your song. Trust me, a music supervisor can listen or hear a song or come on Spotify and listen to a particular song and then try to, want to use the song for a film, and then it just gets stopped at the point of trying to get clearance because they don't even know who owns this particular percentage. And synchronization clearance is the kind of clearance that you have to get a permission from everybody
involved
that
in the
is
creative
involved
process of that work and owns the intellectual property.
You have to get, so even as little or as much as
the person that played the basis.
Yeah, if the
basis,
person has a 2% ownership or a 5% ownership, you need to send contracts and
to that
pay.
person.
Yes. That's how synchronization is.
Wow.
So most times, if you know that you want to earn from that side, your contract is very important because that's only what you can show. Nobody wants to release a movie or an ad and then we are fighting about, take this down, who owns this, who owns what after release. Everybody wants to get it right pre-release. Yeah.
Okay. All right. So hopefully we're looking forward to the next Sync Camp.
Yeah.
I think you need to save me a spot in that camp.
Okay.
Yeah. Let's see what's going on and let's make some music.
Yeah.
So finally, word of advice for creatives, especially when it comes to the intellectual property and every other thing that you've seen.
Yeah. So I would first advise you to continue creating good work. Get a good lawyer on your team. Very important, and also ensure that you sign your contracts are well executed. You read through the lines and understand what your contracts are, and also reach out. You might think that as a creator these lawyers are not available, just like you said, or they're expensive, but reach out first and then you never can say.
Just
so
prepare for the bill, Sha.
It's not like that.
No, but it's actually important because it's more expensive if you don't protect yourself.
Exactly.
That's true. Okay, thank you so much, Koforola,
for
joining us on the show.
Thank you.
And I hope you've learned something, you that is listening on the other side. Before we wrap up, I just want to let you know that this week was the 43 year of compact disc. The compact disc turned 43 years old this week, and if you don't know what that is, well, I don't know, you may need to just Google it and look at what a compact disc used to look for. We called it CDs in our heyday. So it was first released on August 17, 1982 by engineers at a polygram factory in Langenhagen, Germany. And the first commercial compact disc contained the Swedish pop group ABBA's album The Visitors. And if you remember that in the 1990s and the early 2000s, CDs were the whole industry. Everyone owned CDs, and the jewel cases was what made us all crazy about CDs. You have the jacket sleeves containing the album art, the lyrics sometimes, the producers and all of that, but all that is gone now because of Spotify and Apple Music and all of that. But we're just paying tribute to the CDs, and it's 43 years, brings back fantastic memories. But that's the show on the Music Gig today. Thank you so much for being part of the show.